great, a great first venture. Let me see here. Okay, so I wanted to provide some introductions real quick. My name is Jen Cutright. I'm a senior project manager with Langan, and I provide environmental services out of our Seattle office. We have Liz Kimbrell. She provides services for the environmental group out of our Portland office, and then Brandy Gray is out of our East Coast Doylestown, Pennsylvania office. Among the three of us, we've probably completed hundreds of phase ones, and I think we really wanted to provide this like breadth of experience so that today, even though every site is always going to be a little bit unique, we are hoping that we can answer your questions and share some knowledge of enough of the different sites that we've experienced across the East and West Coast in order to answer your questions. So just quickly about Langan, over here to the right, you can see Langan is a multidisciplinary firm. We provide a few different types of services, and our core services are site, civil, environmental, and geotechnical. We've been around for about 50 years, and we're really involved in the ground and down aspect of redevelopment. So we provide services for many sectors, including stadiums, airports, ports, hospitality, industrial, and then of course, housing. Many of our projects have been in the Pacific Northwest, but it actually wasn't until 2018 that we started our office here in Seattle. We have about 37 offices worldwide, but we're excited to have roots here in the Seattle area. So we always start our meetings and presentations with a health and safety minute, but we decided to pivot a little bit today and just do a quick cybersecurity safety minute. I don't know if anyone is aware of the NVIDIA cyber attack that occurred, but it kind of raised eyebrows with us internally at Langan because consumers were affected, and it sort of highlighted the far-reaching effects of cyber attacks. And we kind of took stock of some of our typical practices, and that's what we wanted to share with you. So if you receive an email from somebody, the name might look familiar, but it's always good to sort of hover over the name and determine whether or not you actually recognize the email address or whether or not it's an email address that you've never seen before, in which case don't click on it. Also the same with websites. You might see a link to a website, but when you hover over it, you see it's actually going to take you someplace else entirely. And it's always good to report those emails to your IT department as a potential phishing scam. At home, of course, make sure that your antivirus software is updated, your security updates are good to go, and then if there's a breach, make sure that you have a backup of your data, which is one of those things that I always tell myself I need to do and then haven't done recently, but this is my moment. All right, so we want to get into the phase ones. Our clients use phase ones to make property purchase decisions and to identify environmental risk. So when we saw that the American Society for Testing and Materials, or ASTM, when we saw that they were updating their standard practice, we really wanted to participate in that process and also be ready to share information about these changes as the new standard was established. So Brandy is going to be here to drill into the details of the changes a little bit later, but we also want to make sure that everyone knows that there's some slight changes that are going to happen to your phase ones, and that's going to include how a phase one is completed, the conclusions that are made, the timing constraints, and we want to make sure everyone's prepared for those changes. But before I get into it, I think we just wanted to give a quick little review of what a phase one is. The presentation itself, just so everyone's kind of aware for timing purposes, will be about 35 minutes, and the second half will really dig into the changes that have been made. I know I said earlier that we wanted to kind of get to know everybody a little bit better. I don't know if you guys are able to raise hands or give thumbs ups, but it would be helpful to know whether or not anyone has experience using or reviewing phase ones. I don't know if I can actually even see if people, there you go. Okay, great. So hopefully this will just be a quick refresher, but for people that are less familiar, I think it'll give you a bare bones run through of what a phase one is. Awesome. So the general definition of a phase one is that it's a non-intrusive study. So we rely on existing information in order to evaluate the potential presence of contamination at a property. Generally, the type of research that we review in the phase ones are performed pre-acquisition. We do it as part of due diligence typically, and oftentimes it's done for a potential purchaser, but that's not always who the user is. So when we're talking about the user of the phase one, that's going to be the person that contracted to have the phase one completed. And the phase one is really completed for the user. If it's going to be anybody else that needs to rely on the phase one information, like a bank, you're going to want to make sure that there's reliance letters in place, and we'll kind of all talk about that a little bit more, but I think it starts with understanding who the user is when we're talking about a phase one. So the historical research that we're completing, that we're relying on when we're completing a phase one, includes what we refer to as the big four. Those are aerial maps, fire insurance maps, city directories, and topographic maps. This information, it really gives you sort of like a snapshot of what development looked like at different periods of time. So you might have this documentation that spans like a 100-year period, and then you can review maps from 1930s and topographic maps and city directories from the 50s and the 60s, and it kind of just gives you, it helps you create a story of the development history of your property and of the adjoining properties. So for example, you might see that there was manufacturing that was present in the 60s, but in the 90s, that manufacturing has sort of disappeared and you're looking at like condos or residential type redevelopment. And that general picture, you can kind of get from your aerial and topographic maps. But if you want to drill it down, the fire insurance maps or your city directories might let you know that there used to be an underground storage tank present at the time of the manufacturing, or that cleaners used to be associated with the address at one point. And really, we use all that information to determine whether or not the site history has any environmental risk that we need to be concerned about. Sometimes we'll supplement that with like state and local databases. For example, Ecology has a What's in My Neighborhood database that you can use to see whether or not environmental cleanups have happened at your property, or to review tank records. So this type of research has always been required, but the new standard adds a little bit more to it because it requires that level of review occurs for adjoining properties as well. And again, Brandy's going to drill into this a little bit more, but it's helpful to realize that the level of effort there might be increasing. The other components of the phase one that we talked about or that I kind of highlighted in my previous slide, I guess, are the site reconnaissance. So you're going to go to the site. We want to look in any of the buildings that are present. We want to see where chemicals are stored if they're being used. We want to see where operations are happening and what those operations are. It's also very helpful to conduct interviews. We conduct interviews with the owners of the property, tenants, sometimes it's current tenants or former tenants. There's certainly situations where maybe prior reporting or prior mapping will locate or will show that there was a maybe transformers located at the site. And sometimes we want to like go back and talk to former tenants to find out when those transformers disappeared. Government record reviews can include things like the ecology database that I mentioned earlier, as well as EPA databases. And when we're going through these different state and local federal databases, we always want to submit Freedom of Information Act requests or FOIA requests. That's where we're able to obtain things like environmental reporting that might have been completed for a property. We can find permits or old well records, things like that. We want to have all that documentation, and often it's obtained through a FOIA request. Again, these are not new components of a phase one. These are the basics. It's always been required, but one of the changes is that these elements now have expiration dates. So when we start doing this research, we're going to be documenting when that research begins, because there are implications for the usability of the phase one down the road. So what is all this for? Of course, I'm sure everyone who's ever used a phase one flips to their findings page right away to see what the conclusions are. Just a quick refresher on what that means. So the recognized environmental condition typically means that there's some sort of environmental risk that's been identified, whether it's an existing risk or a future risk. That's what that's going to be highlighting. Oftentimes the conclusions or the recommendations associated with that will be to conduct some sort of intrusive study at the site. We refer to that as a phase two often. Historical and controlled recognized environmental conditions, that usually means that some sort of environmental risk was identified at some point and has been managed or is being managed. There are implications to the presence of historical and controlled recs that Brandy will dive into a little bit more. Other conclusions can be a de minimis condition. So, if we're at the site and we see maybe some staining in a garage, there's not a concern that that's going to create an environmental risk, but we still need to call it out and talk about it in the report. And then, of course, the more we understand about the development that's going to occur, the more we can help identify business environmental risks. So, for example, if we know that there's going to be redevelopment at the site, but there's maybe some old demolition debris or concrete material or something, that's not necessarily an environmental risk that we're concerned about, but it's something that you're going to have to manage during your redevelopment, and so we call it out to you for that reason. So all of this research takes time, and it can take some diligence to acquire, and it's not uncommon that some of this information is available to you as the user. So the user can definitely help streamline the completion of the phase one and just give a little bit more time to review the information and provide really robust conclusions. If you're the user and the phase one is being completed on your behalf, it's definitely good to be as candid as possible with the information that you have. It's good to provide all the documentation you have. Things like title records and activity and use limitations, that's documentation that we have to review now as part of the new standard. And oftentimes this can be obtained during like pre-acquisition negotiations, and so you can kind of hand over that information once it's disclosed to you. Also, being able to provide site access can really help. You can't imagine how many times the site boundaries is just something that hasn't really been nailed down at the time that the phase one is requested. And to really make the historical research as efficient as possible, it's good to know what the site boundaries are as soon as possible. Also wanting to make sure that the access is provided to complete that site reconnaissance. We need to enter the building, we need to see the rooms where different operations are occurring. And if we can't because there's access issues, it does get called out as a data gap. And then finally, like I mentioned earlier, if there's other parties that are going to need to rely on this phase one, it's great to start negotiating that ahead of time and make sure that reliance letters are going to be included in the scope of work. Similarly, you want to know what's not included in that phase one scope of work. So asbestos surveys, wetlands delineations, that's not a typical part of a phase one scope. Certainly, I think many companies that provide phase ones can provide some of these additional needs, but you have to negotiate that ahead of time. So it's just great to be aware of what's not included in a phase one scope of work so that you can negotiate and include that in the contract for your phase one needs, or know ahead of time if you need to have somebody else do that for you. And then also, and Brandy will discuss this a little bit more, but contaminants of emerging concern are also something that's not included in a phase one scope. I think a lot of times that's something that I would discuss with a client. For example, if there was a concern that it might be present, but it's not a part of a phase one scope, and so you want to kind of be aware of that. So with that, I want to hand it over to Liz to talk about phase ones just a little bit more. If there's any questions about what a phase one is and some of the stuff I just ran through, please don't hesitate to pop questions into the comment box, and we can jump in and answer for you, or we'll answer at the end of the presentation.
Sounds good. Thanks, Jen, and good afternoon, everyone. Now that we know more about the components of a phase one, let's talk a little bit about why phase ones are needed. Next slide, please. Phase ones are typically prepared for three main reasons: liability protection, contract negotiation to make go, no-go decisions about property purchases, and to identify and plan for potential environmental risks after the property is purchased. This slide talks about liability protection. So our clients and their lenders often seek the innocent landowner defense and other defenses provided under CERCLA or the Superfund law. The innocent landowner defense allows the buyer of a contaminated property to defend against liability of hazardous substances or other environmental contaminants that may have been placed on the property by an unrelated third party. In addition, as you probably all know, failure to perform a phase one prior to purchase of the property may leave the buyer liable for all environmental investigation and cleanup costs discovered on the property during development or after the property is purchased. Next slide, please. The second reason we conduct phase ones is for contract negotiation purposes. By identifying environmental concerns in the due diligence period or prior to the property purchase, the buyer can negotiate one or all of the following items listed on this slide. The first of which is the reduced purchase price. So the price of the property may be lowered or reduced due to the depreciation of value of the property because of the environmental issues that may be encountered on the property. The reduced price may also be to offset costs associated with addressing environmental issues after the property is purchased. And that actually leads into the next item, which is set-asides, which are allocations of money such as environmental cleanup escrows to cover potential future environmental costs. The next is environmental responsibility, which is during these contract negotiations, you can identify who maintains responsibility and liability for cleanup of the site. This could be the buyer, the seller, or another third party. You can also use contract negotiations to set up key project milestones. So for example, if a property has environmental impacts that require a remedial action plan or a soil and groundwater cleanup or management plan, these can be identified during the contract negotiation process. And specifically, the party responsible for preparing those deliverables and the dates that they are due can also be identified in the contract. Next slide, please. And the last main reason we perform phase ones is for prospective purchasers is for planning and design purposes. By identifying environmental concerns during the due diligence period, the buyer can identify a number of items, 4 of which are listed on this slide. The first is property use limitations. So another example would be if a prospective purchaser wanted to buy a property and develop it into a multi-unit residential housing complex. Say this potential property is currently occupied and is being used for commercial industrial purposes. But due to environmental impacts or issues on the property has been restricted for residential use, meaning it cannot be developed for residential use without next steps being completed first. For example, environmental investigations, mitigation, or even remediation. So you as the potential buyer would want to know if there was this property limitation on your property and what the potential next steps would be to move forward with the regulatory agency, ecology, for example. You'd want to lift this restriction and be able to develop your property. So you'd want to identify this potential use limitation. In addition to the use limitation, there could be other site constraints like limitations on stormwater management. There could be engineering or institutional controls like engineered caps or remediation equipment that may need long-term ongoing monitoring and maintenance. In addition, there may be some health and safety requirements or concerns that you'd want to know about that may need to be implemented during construction or even occupation of the property. So for example, you may have environmental impacts in soil, and say you plan on developing the property and your development requires some excavation of that environmentally impacted soil. You may want to know and identify some potential health and safety procedures that should be adhered to by your construction workers during development, like additional PPE, personal protective equipment, or you may want to use dust mitigation measures during development. Those can also be identified here. And then finally, the phase one could be used to identify other costs like construction and engineering cost premiums. In the previous example that I just mentioned, if you have a site that has environmental impacts in soil, that soil may need to be handled a certain way and then disposed of at a licensed landfill disposal facility at an added cost. So that could be identified here as well. Some other engineering cost premiums might be if you purchase a property that has some potential impacts in groundwater that may require a vapor barrier or membrane to be installed before the site can be occupied. That's an additional engineering control and cost that you'd want to maybe consider at this stage prior to purchase. So in summary, phase ones are used for a variety of reasons, all of which are important for prospective purchasers to handle and manage potential environmental risks, including long-term liability and the big one, managing potential costs. Next slide, please. Next, we'll talk about the role of ASTM and standard practices in preparing phase ones. We follow ASTM standard practices when conducting phase ones because the EPA has acknowledged that the past ASTM standards meet the requirement for the all appropriate inquiry under CERCLA or Superfund. So as we've mentioned previously, in November 2021, ASTM published an updated standard for preparation of the phase ones called ASTM E1527-21. And the 21 refers to the year that it was prepared. This replaced the ASTM standard E1527-13, which was prepared in 2013, which has been used for the last 8 years. Each time a new version of the ASTM 1527 standard is created, revisions are reviewed by the EPA to verify continued conformance with that all appropriate inquiry requirement. And currently, the EPA's review of this new standard is ongoing, and we'll talk about this in a couple slides, but we anticipate EPA approval of this new standard soon. Next slide, please. So why did ASTM update their phase 1 standard? Well, phase 1s require a pretty high degree of professional judgment and interpretation. And because ASTM acknowledges the evolution of commercial real estate and access to information, there is a requirement to update the standard practice every 8 years to clarify language, improve consistency in report deliverables, and ensure that it reflects good commercial and customary practice. And in this latest review in 2021, ASTM found that in fact, phase 1s are not being performed consistently. So actually, the goal of this 2021 update was not to expand the scope of the phase 1, but to bring consistency to phase 1 reports. And the goal is actually listed here on this slide with emphasis in red. Consistent practice resulting in, consistent rigor to provide consistent deliverable, and consistent being the key word there. So now we'll devote some time in the next slides to talk about the key changes between the 2013 and 2021 ASTM standards, and Brandy's going to talk about that. But before we do, we just wanted to note a big question that we often get asked is, when do our phase 1s need to be reflective of the new 2021 standard? And unfortunately, the time frame for US EPA adoption isn't known, but some reports say that it'll be a year before the EPA approves of the new standard. So we anticipate the approval to be coming soon, since the new standard was established in November of 2021. In the meantime, until the EPA acknowledges that the new standard meets that all appropriate inquiry requirement, phase 1s should be prepared in accordance with the 2013 standard, as this standard has EPA approval and meets that all appropriate inquiry requirement. However, it is still good to understand the changes in the standard and the difference between the two standards, so we can be better prepared when the EPA does approve of this new standard. And then we can more easily, more quickly implement the changes to prepare phase 1s in accordance with the new approved standard. So with that, let's transition it over to Brandy, who's going to discuss some of these key changes in much more detail. Brandy?
Thanks, Liz. Good afternoon, everyone. As Jen and Liz mentioned, in 2021, ASTM updated their standard practice to complete a phase 1, and I'm going to provide an overview of some of the major changes. I'm going to discuss some changes to several of the definitions, the shelf life of a phase 1, historical resources, which are referred to as the Big Four, activity and use limitations, or AULs, emerging contaminants, and changes to the title search requirements. Next slide. So I'm going to start by discussing the definition of a recognized environmental condition, or a REC. This definition has been updated in the 2021 standard to provide better clarity and to allow for more consistent interpretations. I want to point out, though, that although it's been updated, the meaning of a REC has not changed. So in 2013, a REC was defined as the presence or likely presence of any hazardous substances or petroleum products in, on, or at a property. And then the definition went on to discuss 3 conditions. 1, due to any release to the environment. 2, under conditions indicative of a release to the environment. Or 3, under conditions that pose a material threat of a future release to the environment. The 2021 definition of a REC, as mentioned, was reworded. The first and third conditions have essentially stayed the same, 1 being a release to the environment and 3 being a material threat of a future release to the environment. Condition 2, however, was updated to say a likely release to the environment, and I'll go into that in a little bit more detail later on. Next slide. So let's break this down a little bit. Condition 1 of the definition talks about the presence or direct evidence of a release to the environment. And this is, fairly straightforward. You have evidence of a release that was observed during a site visit. There's analytical data that indicates elevated levels of contaminants. Information reviewed during file reviews or a database search identified a release, or just an interview with an individual that has direct knowledge of a release at the site. Next slide. Condition 2 of the definition talks about likely presence. So what does that mean? In general, it means that it is unknown if there is or was a release to the environment, but based on knowledge, available information, and professional opinion, it's reasonable to believe that a release has occurred. Things that we consider as it relates to a likely release may be, have there ever been hazardous substances or petroleum products at the subject property? What are or were the operations at the site? Do they have good housekeeping? Do they have good work practices? What was their regulatory oversight during the time of operations? Are there any potential offsite sources? And what are the locations of those offsite sources with respect to the site? So distance, how far away is it? Is it up gradient? Is it down gradient? What is the likelihood that those offsite impacts would impact the site? Next slide. And condition number 3 talks about a material threat. This is in general a threat of a release in the future that will impact public health or the environment. And we have an example here on the slide. We have an above ground storage tank, or what we call an AST, containing hazardous substances or a petroleum product, and it's in poor condition. The tank is rusty, it's exposed to the elements. And although there isn't currently a discharge from the AST, based on the current condition, there is a threat of a discharge in the future if the AST is not properly addressed. Next slide. So this slide highlights the differences between a REC, a historic REC or an HREC, and a controlled REC or a CREC. So we just talked about the definition of a REC. A CREC is a subset of a REC. It is a past release that has affected the subject property, and impacts remain above unrestricted use criteria, but they're addressed with controls. So say a cap or a use limitation. If there are no controls in place and the impacts exceed unrestricted use criteria, then it would be considered a REC. Then we go on to an HREC. An HREC is a past release that has affected the subject property, but analytical data meet unrestricted use criteria. I do want to point out that you do have to consider the current regulatory framework when determining if you have an HREC or a REC. So just because a release was addressed to meet unrestricted use historically, it may not meet unrestricted use today, and as such would be a REC. An example of this might be a tank that was closed at the subject property in the 1990s that may not have been evaluated for vapor intrusion, or post-closure samples may now exceed current unrestricted use standards. You would have to reevaluate the data and determine if it still meets unrestricted use. And if so, it would fall under the category of an HREC. But again, if it doesn't, it would be considered a REC. Next slide. The actual time frame for the viability of a phase 1 has stayed the same. The phase 1 is good for 1 year prior to the date of acquisition, provided select components are completed or updated to within 180 days of the date of acquisition. After 1 year, the entire phase 1 needs to be updated. The components that are required to be updated to within 180 days of acquisition include the site visit, interviews, the lien search, review of government records, and the declaration by the environmental professional. So what has changed is really the start time for the 180 days / 1 year time frame. Historically, it was assumed that the clock started when the report was completed. However, the standard does now specify the 180 days / 1 year starts from the completion of the first component. So for example, your interviews were completed on September 29th, the review of government records was completed, say on October 3rd, and the report was completed on October 12th. The earliest component was the interview, which was completed on September 29th. As such, day 1 of that 180-day 1 year clock is September 30th. To make it a little easier to recognize when updates are required, the dates of the key components are now required to be listed in the report. So you can just go right into the report and see the dates and make a determination of when the report is going to expire. Or excuse me, the phase 1 is going to expire. A key side note here is I just want to point out that a phase 1 update isn't a small endeavor. There's a lot that goes into those 5 components that I just discussed. There's a lot of detail and research. So keep that in mind. Also, I wanted to point out that we're often asked for reliance letters for phase 1s that are more than a year old, and we cannot provide a full or we cannot provide a reliance letter without a full update. So again, keep that in mind if you are running into some timing issues. Next slide. So the biggest change in the standard is probably the historical record review section, which Jen touched on earlier in the presentation. The 2013 standard only required you to review as many historical sources as needed to meet the objective of determining if past uses could have led to a wreck. However, the 2021 standard requires review of at least 4 historical records, which are now referred to as the Big 4. And these include aerial photographs, topo maps, fire insurance maps, and city directories. Another big change is review of the Big 4 is also now required to understand historical use for adjoining properties. Adjoining properties are defined as properties that abut the property boundary, but also may be located across a street or an alley or railroad. A lot of people don't realize that the adjoining property extends beyond those easements as well. If one or more of the Big 4 sources cannot be reviewed for the subject property or adjoining properties, a statement to explain why is required in the report. And just to point out, these particular changes were primarily brought about due to dry cleaners and the need to identify them. They pose a significant environmental liability. Dry cleaners are also why there is now a focus on retail at subject properties and adjoining properties as well. Next slide. So there used to be a property use restriction listed in the 2013 standard, but it was pretty broad. Is there anything at the site that may restrict present or future use? Property use restriction has now been replaced with the property use limitation. And essentially this is a 10,000 foot look at your site to see if there is a release that would affect the property. The standard does not require you to provide a lot of detail on that, but the purpose is to just identify if there's something there. Next slide. So if you have a property use limitation, which again is that 10,000 foot look at your site, it may meet one of the new definitions of the activity use limitation, or AUL. And this is really 1,000 foot look at your site. So there can be engineering AULs. This includes a cap, could be a slurry wall, a groundwater treatment system. These are your physical controls at the site. Or there could be institutional AULs as well. And these include a deed notice, environmental lien, environmental covenant. Another example is a declaration of environmental restriction. These are your administrative controls. Next slide. So what importance does the presence of an AUL have on the future utilization of a site? We can take a quick look at these 2 examples. The first example is residential versus non-residential. So you have an industrial facility, you have impacts that are capped, you're allowed to continue use at the site as non-residential. However, say years later, the property's up for sale and the buyer wants to make the property into residential homes. In this case, additional remediation would be required to allow for residential use at the site. So take that same scenario, however, the site is proposed for continued non-residential use. Because there's a cap at the site, there may be ongoing monitoring, maintenance, and reporting requirements associated with the cap. So in either scenario, additional costs could be incurred and it could be a deal breaker. So again, important to understand if there's an AUL that exists at the subject property. Next slide. An AUL can be identified through review of title search records, a database lien search, or through review of federal, state, and local records. And these are all typically reviewed by the environmental professional as part of the phase 1. Next slide. The title search requirement has been updated in the 2021 version of the standard. It states that the user, which is typically the client, has to provide the title search to the consultant going back to 1980. This is something that Langan can provide, but again, that would be at additional cost to complete. It's not part of the scope. Again, it's required that the user provide that information. If a title search can't be provided or completed within the time frame needed for the phase one, you want to discuss that with your consultant, because if it's not completed, this would be identified as a data gap. And I want to note that, again, the importance of the review of the title search. The title search is the place where we would find the AULs for a subject property. Okay, next slide. So the definition of the significant data gap has been added to the standard as well, and it's defined as a data gap that affects the ability of the environmental professional to identify a wreck. An example of this might include not being able to access a boiler room during the site reconnaissance. Because there's a potential for a discharge to occur related to the boiler, the inaccessibility to this room could result in a significant change to the conclusions of the report. So again, it would be called out as a significant data gap. Next slide. Moving on to contaminants of emerging concern, which many of you are probably familiar with the term, as this has become a nationwide issue. The group of emerging contaminants getting the most attention in the news right now is per and polyfluoroalkyl substances, or what's known as PFAS. As you recall, a wreck is defined as a petroleum product or a hazardous substance. The US EPA has not yet identified PFAS as a hazardous substance. As such, the presence of an emerging contaminant as subject property is not considered a wreck. If they are identified, they would be considered they're considered non-scope issues, and if they're identified, they would be considered a business environmental risk. Again, emerging contaminants are important to look at, as this might affect future risk and liability down the road if they are identified as a hazardous substance. Next slide. And with that, I will open it up to questions. But before we do, we threw a lot of information at you, and really we want you to walk away knowing that ASTM updated their standard practice to complete a phase one. This was done to provide more clarity and to eliminate inconsistencies or subpar phase ones. Although there are several changes to the standard, overall, this is not really going to affect phase ones that are being completed by some of the more reputable firms, because a lot of these changes were already being implemented in phase ones. I also want to point out that a cost of a phase one shouldn't be affected too much for sites that are in rural areas. However, you may see an increase in cost for sites that are in more highly populated areas due to the requirement of research into adjoining properties. And that's all I have.
I'm going to pop up just our contact information while we look at questions and kind of go over that, because obviously if something comes up that you aren't able to ask during the presentation, we're very happy to have you reach out to us and answer questions offline.
Thank you all so much. What questions do folks have? You can go ahead and unmute and ask them, or you can pop them in the chat.
So I know you were talking about phase ones, obviously, but for a phase two, just curious whether or not on reliance letters, you mentioned not being able to provide a reliance letter if a report is more than a year old. Is that kind of blanket for all environmental reports, or just phase ones?
I don't know that I've done a reliance letter for a phase two before. Generally, it's for the phase one, because that's the document that's usually required by the bank, that has the time frame associated with it, and that usually has the disclaimer saying that only the user can rely on the information. So I think it only applies to phase ones.
Gotcha, thanks.
There's a question in the chat about getting access to historical property data, historical resources, or the big four. I would say there's a lot of ways to access the various historical data. I'll let Brandy and Liz chime in as well, but in my experience, there's resources where you can literally contract to obtain this information, but there's also other like database resource sites that will give you, each individual type of historical information. I've also gone to public libraries and searched historic maps on my own that way. So I'm not quite sure if that answers your question or not, but there's not like an easy way to just obtain all the historical information for your property. It usually requires, a significant amount of research. And if that doesn't answer your question, feel free to ask more, Sheila.
And just to add to that, Jen, it also depends, of course, on where you're located, which city, county, the resources that you would rely upon to get those historical records is highly variable depending on where your site is. And it's good to work with your consultant and identify what those resources are so we can make sure we tap into all of the resources possible for where your site is located.
And with regard to the question about whether or not we're sending out the recording, I think that's up to Lauren. I'm not sure what the answer is to that. I know I wanted to chime in. We were discussing typical questions that have been coming up for us as we've been sharing this information with clients and discussing it internally. And one of the questions that we've talked about quite a bit has to do with the change to the REC definition and when you're identifying whether or not there's a likely presence. It definitely comes off as seeming like there's a lot of judgment, a lot of professional judgment that comes into play when you're identifying a likely presence. And I do feel like it's important to point out that there's sort of like a checklist that you would go through to determine whether or not something counts as having a likely release or a likely presence of impacts. So it has to do with, the type of use, it has to do with the type of storage, it has to do with the, if we're talking about maybe like a tank that was identified and whether or not there's a likely chance of a release, we'd be evaluating the condition of the tank. Like there would be specific items that we would evaluate. So it's not just an arbitrary application of that definition now when it comes to identifying a REC. Brandy, does that kind of vibe with what you've been discussing as well?
Yeah, I was just going to say one of the things that ASTM did this time is they have an attachment now, and it really gets pretty granular into the definition of a REC. So there's a lot less, I feel like, a lot less wiggle room to be able to say, oh, well, we can say this isn't a REC, or we can say this isn't a REC. So it really gets granular, provides a lot of different examples of, if you have this and this, it would be this. And it's really a good tool that they added, again, for consistency, because, you put a bunch of different consultants in a room and you could go back and forth on what's a REC and what's not a REC, and you'll get 4 or 5 different answers. But I think this, adding this attachment and this additional granular information it really helps support, your decision in making it a determination if it's a REC or not.
Yeah, and I think from the user standpoint, that gives you plenty of fodder to ask questions about RECs. How is this identified as a REC? Can you kind of take me through the thought process? And there should be a clear checklist to take you through.
I can also chime in here. One question that we've been asked a lot lately is, what's one of the top things that clients should be doing if they're seeking liability protection under the all appropriate inquiry requirement? And one of the key takeaways that we've been talking with clients about, and Brandy, chime in if you have anything to add to this, is getting those title searches completed, including the search for the activity use limitations, as well as environmental liens that Brandy talked about in detail, and making sure that those are included in your consultant's scope to prepare the phase one, as the new standard clarifies that this is a client or a user requirement now.
Yeah, and I'll just say, you know, if the consultant ends up having to do that work, it does take some time. That's one of the lengthier things that we have to go through to get the information and then to go through it. So if it's something that you as a client or a user can't provide to your consultant, definitely discuss that up front, as there's, again, additional costs associated with that. And you want to make sure that you get that completed in time. Otherwise, again, it would be identified as a data gap and could be a pretty significant data gap, which affects your report.
Any other questions? I see a question in the chat from Rie about what's considered adjoining properties in urban settings.
So this is definitely something that comes up a lot. An adjoining property is defined as anything that abuts the property. So even so, you have your northwest, east-south direction. It abuts the property boundary. You may have a property across like an intersection that just the corners meet. That would still be considered adjoining. As well as anything that's across a street or a stream or a river, anything like that. If that stream, river, railroad, whatever, wouldn't be there, the property would adjoin. That's all considered adjoining and meets that definition and the additional work that needs to be completed.
Great. Any final questions or comments or thoughts for Brandy, Liz, or Jen? Well, I want to thank the three of you so much for all of the great information that you've provided today. I want to encourage everyone to reach out either through me, and I'm happy to connect you, or through the contact information listed on the slide. And we're really grateful to have you on as members and for the information that you provided today. So any last comments from the three of you?
Well, I definitely want to say thank you again for giving us the opportunity to present. We are happy to continue to share information like this, as it's requested or needed, and please don't hesitate to reach out. And also, I look forward to hopefully meeting more folks in person at some of our future upcoming events.
Yeah.
Yeah, I was just going to echo that. Thank you, everyone. And we hope to connect with you, hopefully in person, although virtual is good for now, but hopefully in person at an upcoming event. So thank you for joining.
Yes, thank you.
Hope to see everyone at our annual celebration on March 29th. You can attend in person if you feel like you are comfortable doing so, but it is also streaming online if you would rather watch it from the comfort of your home. But looking forward to seeing everyone, and thank you, and see everyone soon.
Thank
you, Lauren.